Louisiana Governor Jeff Landry recently signed a law requiring every public school classroom in the state to host a display of the Ten Commandments.
The people of Louisiana in a bipartisan measure spoke through this bill.
And said the displays simply reflected the role of religion in American history. The displays immediately sparked fierce activist opposition.
If we allow Christianity to be ever present in our schools, then we will slide down that slippery slope of dictating what people can and cannot believe.
This Louisiana law is at the heart of one of the great controversies in American legal history. When does the government go too far in promoting religion? This question has been confused by decades of bad Supreme Court rulings and a widespread misunderstanding of the role of Christianity in our founding.
So if we go back to the early colonies, there is not religious liberty in America. States like Massachusetts Bay, they just banned Catholics. They banned Quakers. Virginia banned Catholics as well. These states required church attendance. They put people to death for blasphemy. Fortunately, by the time we're getting to the late 18th century, Americans are recognizing that this is not a good thing. This is reflected in the First Amendment. Congress shall make no law respecting the establishment of religion. So we aren't going to have governments telling churches how to govern themselves. We aren't going to require people to go to church. We aren't going to have religious tests for office, right?
Can you tell me a little more about Thomas Jefferson? Because he's kind of the poster child for this strict separation, the wall between church and state.
We know he's not an Orthodox Christian. He denies the virgin birth, the incarnation, miracles, things of this nature. Jefferson wrote the Virginia Statute for Religious Liberty, which basically said we aren't going to fund any churches in the state of Virginia, and also that we won't have religious tests for office. But even he didn't see it as keeping the government out of the business of religion altogether. For instance, as governor of Virginia, he invited his fellow Americans to join him in prayer. Jefferson also made the War Department building and the Treasury Department building available for church services. So in his own life, in how he acted as a political official, Jefferson did not seem to believe there was a wall of separation between church and state.
But there's a conundrum at the heart of the Establishment Clause. While the founders were uniformly opposed to government imposing religion, they did think religion, especially Christianity, was extremely important to the founding of the country.
Yeah, there's no question that Christianity had a very important influence on most founders. In the founding era, as late as 1776, of Americans of European descent, 98% are Protestant, 2% are Roman Catholic, and you have maybe 1,500 Jews in a couple of American cities. So I think the founders were profoundly influenced by Christian ideas. The founders, to a person, were convinced that humans are created in the imago Dei, the image of God. It also means we're all instilled with dignity and should be treated with respect.
If people have dignity, then they need to be accorded rights to protect that dignity. This is the religious inspiration for the huge number of rights accorded all citizens at the founding. The founders also believed that to keep the American experiment going, people need to use those rights responsibly. The people must be moral. George Washington famously said in his farewell address that of all the habits which lead to political prosperity, religion and morality are indispensable supports. That is, in order for a republican form of government to work, you must have a moral people. And in order to have a moral people, you must have a religious people. This conundrum is reflected in the Louisiana case. Christianity is integral to America. But does this display go too far? So, what are your thoughts when you first heard about Louisiana's law, and why do you think that it passes the Establishment Clause challenge?
There's no good argument that would cross the Establishment Clause line. If we want to understand American history, we have to understand the role religion has played within that. Something like a passive display of the Ten Commandments in no way would have been viewed as coercive by anyone. No one would have considered that to be an establishment of religion.
This is the founders' vision. A government that would not compel people to be religious, but that could acknowledge this essential role of religion in American life.
There's all sorts of buildings in Washington, D.C. with scripture engraven on them. In the Supreme Court, multiple copies, yeah. Now, it's just all over the place, and no one ever considered that to be an establishment of religion. And then there's a long history and tradition of monuments of the Ten Commandments being on public property. After World War I, we expanded that to include Stars of David. And today we have something like 85 religious images that can go on soldiers' tombs, entirely appropriate.
The founders' vision held for nearly 2 centuries. Then in the 1970s, the Supreme Court stepped in and profoundly altered how courts think about the Establishment Clause. In the 1971 case of Lemon versus Kurtzman, the Supreme Court came up with a new test for courts to use when Establishment Clause violations are alleged. They should look at whether the law has a secular purpose, if its principal or primary effect advances or inhibits religion, and if the law fosters an excessive entanglement of government with religion. The justices thought they would resolve the court's Establishment Clause conundrum. It was the exact opposite.
All sorts of things were held constitutional and unconstitutional, things that were incredibly similar. The U.S. Supreme Court said that a public school district couldn't loan maps to a private religious school, but it could loan textbooks that had maps in them. The U.S. Supreme Court said that you could subsidize busing children to private Catholic schools, but you couldn't subsidize children from private religious schools to field trips.
The Lemon test was also applied in the 1980 Supreme Court case of Stone versus Graham. There, the court struck down a Kentucky law mandated a display of the Ten Commandments in public school classrooms. Over the last decade, the Supreme Court has steadily dismantled the Lemon test. In American Legion versus American Humanist Association, the court concluded that the Bladensburg Cross, a 32-foot Latin cross World War I memorial that stands on public property in Maryland, did not violate the Establishment Clause. Justice Samuel Alito noted that the Ten Commandments have historical significance as one of the foundations of our legal system. 2 years later, in Kennedy versus Bremerton School District, the Supreme Court vindicated a public school football coach's right to privately pray after games. Justice Neil Gorsuch's opinion rejected the, quote, ahistorical Lemon test. Shortly after Governor Landry signed the Louisiana law mandating displays of the Ten Commandments in classrooms, the American Civil Liberties Union sued. It claimed the Ten Commandments are not a source of American law, and that having the displays would unconstitutionally expose some people to a religion they don't believe in. A couple months later, a federal judge ruled in the ACLU's favor, and the state appealed to the Fifth Circuit Court of Appeals. We can expect the case to be brought before the U.S. Supreme Court. Given the Supreme Court's rejection of the Lemon test and its many cases upholding public displays of religion, surely it will find this Louisiana law constitutional.